The common law essay question from February of 2002 is not an easy question. It is, however, a somewhat straightforward question, and it's a question that my approach can streamline and make a lot easier to respond to. Have a look at the call of the question. Assembly brought suit in federal district court against city, alleging that 1. City's ordinance was invalid under the due process, equal protection, and takings clauses of the U.S. Constitution, and 2. City's denial of the Assembly's application was invalid under the due process clause of the U.S. Constitution. Well, at least they give us the constitutional theories of liability. What we're going to need to do is apply our approach to make sure that we cover all of the threshold issues. And that's going to become evident after we read the fact pattern. So let's go and have a look at that fact pattern. At the top of the question, in paragraph 1, we see that a town called City has recently started to grow a great deal. This is putting pressure on the infrastructure. And in paragraph 2, with this background, we find out about the Assembly of Future Life. I like the way it's described. Its members adhere to certain unpopular religious beliefs, but they leave those beliefs to our imagination. The city gives the Assembly preliminary zoning approval for plans to build a worship center on a parcel the Assembly already owns within the city. The Assembly's plans incorporated a dwelling for its minister, and right after this zoning decision was made, the city newspapers feature articles about Assembly and its members' beliefs, and presumably how unpalatable those beliefs are. In paragraph 3, shortly after these newspaper articles appeared, City adopts a slow growth ordinance, and paragraph 3 gives us all the details about a lottery for development. And this is going to be the core of the dispute. Now, let's just stop after our consideration of the first 3 paragraphs. Do you think that the city adopted this slow growth ordinance in order to prevent the Assembly from building its worship center? It seems to me that the common sense answer to that question is no. The city passed this ordinance because the city's infrastructure is getting choked by the explosion in development. So personally, I look at these 3 paragraphs, and although I do see a correlation between the Assembly and the slow growth ordinance, I don't see a causation. It seems to me that the motivations of City in passing this ordinance are in good faith, rather than being with some intent to discriminate against an unpopular religious group. In paragraph 4, we find out more details about the lottery itself. Over 500 applicants participated, and there's only going to be 50 permits. So only about 10% of those in the lottery are going to be winners. So the Assembly submits an application for retroactive final zoning approval and a building permit, and that application's denied. And so then we have the federal lawsuit. Number 1, the city's ordinance is invalid under due process, equal protection, and takings, and the city's denial of the Assembly's application, presumably the application for retroactive permits, was invalid under the due process clause. And now we get the final question: what arguments can the Assembly reasonably make in support of its allegations, and is each argument likely to succeed? Discuss. Well, perhaps once again I'm going to show my true colors as a defense lawyer, but I think this plaintiff loses all the way across the board. Let's go through and take a look at my outline and then my analysis. But first, a caveat. Plenty of successful answers to this question reached conclusions that are the opposite of mine. So just because I have, I think, the mainstream answer, and I think you'll agree, the answer that I present is well organized, sensible, and on its face, consistent internally, I don't want you to get the impression that this is the only correct answer. There were plenty of people who reached different conclusions looking at these same facts, and that's entirely as it should be. So let's have a look at the outline that I present. Here, the most important work that my approach allows me to do here, well, it doesn't really allow me to do it, but it helps me to do it, is set up the preliminary issues. Notice we have a private plaintiff going up against a local government, and that means we have to consider standing, ripeness and mootness, and state action. As we'll see, all of these are fairly easy, and they're easily met in this discussion. So, although I'm going to hold with the defendant throughout the substance, I agree that the plaintiff has the right to bring these claims in federal court. So, then, you'll take a look at the remainder of part 1 of my outline, and you'll see that all I'm really doing is listing the various problems that could be raised. And that's it. So, internally, all I'm doing is treating all of these different line items as calling on me to write short answers, rather than some elaborate, complicated essay. Next, we turn to the second call of the question about the Assembly's challenge to city's denial of its application for a retroactive zoning and building permit. Here again, for outline purposes, I just don't think there's anything to do beyond listing what they give us and then putting my real energies into finding a home for the facts and connecting them to legal analysis that one hopes will hang together as some sort of coherent whole. So now let's have a brief look at the answer that I've got for you. I want to give you a few further specific ideas about what I was doing and what I was thinking as I created this answer. Hopefully that'll be of some use to you as well. Have a look at the very first paragraph of my answer. Notice that I lead with the facts. I identify Assembly, I indicate their situation, both politically and procedurally, and I indicate the purpose of the litigation. Next, I turn to the preliminary issues. I set them up by a quick one-liner. Well, actually, I guess it takes a couple of lines about what we need to consider before we get into the merits. First, we begin with standing. You'll see here, up front, I lead with the law, and then I fill in a discussion of the facts that connects to this law. I establish standing. Then we move on to consider ripeness and mootness. Here again, you'll see that I'm finding a home for plenty of facts, and the bottom line appears to me to be that the association, the Assembly, has got standing, and that there are not ripeness or mootness problems. We move on to state action. You'll see here, I toss it off in just 2 short sentences as well. I don't think this is hard to prove, but the big error would be leaving it out. I present it coherently, quickly. It isn't really at issue, but I want to show the graders that I appreciate that these threshold issues are necessary to consider before we can get to the substantive issues. So the bottom line for part 1 is the Assembly's challenge is going to be litigated. They have standing, and the case is ripe for litigation. So now we move on to the actual constitutional arguments. And here, the plaintiff is in for some pretty rough handling as far as I'm concerned. But look at how I set up the substantive due process issue. I go with it first because that's the way they give it to us. I do think that this is the strongest argument that the Assembly is going to be able to bring. And you'll see how I phrase it right in my introduction, the very first paragraph under substantive due process. I characterize, on behalf of plaintiffs, the argument that city has passed this ordinance as a thinly veiled effort to prevent the Assembly from building its worship center. And I explain a little bit about the religious issue right up front. Then I indicate that if we agree with the plaintiff's core argument, then there would be a strict scrutiny application, and the second paragraph under substantive due process goes into that in great detail, including presenting the legal standard, which I think you need to memorize. Not because we always want to bark it out, but because we always want to make reference to it and connect it to the facts of the pattern that we are analyzing. So, next, I basically make the city's argument, and I characterize it as being the stronger case. I think that there's going to be a rational basis analysis, and the result of this will be an easy validation of the slow growth ordinance on that standard. So, next we turn to procedural due process, and here I think the Assembly's arguments are a lot thinner, and the conclusion is really reflected throughout my analysis. I reach the bottom line that Assembly's procedural due process claim is likely to fail. Next, we move on to equal protection. And here you can see up front that I present both the law and the facts. If Assembly is going to prevail under an equal protection theory, it has to show and establish that it was discriminated against because of their efforts to exercise their religious beliefs. And if that is the motivation of the city behind its ordinance, once again, there will be a strict scrutiny standard applied. I note in paragraph 2 that this ordinance does not expressly discriminate against the Assembly. On its face, it's neutral. But I focus more on the issue of discriminatory intent. And I just don't think the facts satisfy that showing. I don't think the plaintiff can make this claim, and as a result, I find that the Assembly's equal protection claim fails. So now we move on to the takings argument. This is a somewhat more sophisticated argument, and the takings cases really have exploded since I was in law school. Most of our current law about Fifth Amendment takings dates from the era of the Rehnquist Court and later. So we focus here in this section on what the government has to do in case of a violation. And the answer is they've got to pay just compensation. But here, in this situation, the city hasn't condemned the property and it hasn't physically occupied it. So there has not been a per se taking. Here, also, the Assembly has not been denied many reasonable uses of this property. It just hasn't been allowed to do a lot of development on the property. So I conclude that the takings case is going to fail also. Here, as in many other aspects of this essay, other passing essays disagreed with me, although I maintain that the conclusions that I am presenting here in this answer are the mainstream answers. The bulk of the successful answers reach the conclusions that I have. Finally, we turn to Assembly's challenge of the city's denial of its application for a retroactive zoning approval and building permit. Here, there's only due process arguments being made, and so I deal with substantive and procedural due process. The problem for us as bar exam essay writers is there aren't any new arguments to make here. These due process arguments essentially are reruns of the earlier arguments. Fortunately, we went into a lot of depth earlier, as I encourage you to do when you face an issue first, answer it in great depth, unless it really is important to consider that analysis later, in which case, the first time it comes up, mention it and explain you're going to deal with it later. Here, by the time we get to these due process issues, we've already discussed them in some great depth. That's why I give each of them only one paragraph in my model answer. Have a look, though, and see if you don't agree that, taken as a whole, I've covered the due process section about as thoroughly as one reasonably could be expected to do under time pressure. So the last word that I have in this essay, my conclusion, is that the city's denial of Assembly's retroactive application does not offend any constitutional standards.